Good evening, everyone. Welcome back. Minister, do you have any opening remarks before we get started?
Thank you very much. Good evening, everyone. I'm pleased to be here to provide the highlights of the Ministry of Justice and Attorney General's 2021 financial plan and to answer your questions. Usually in the past, when we've completed these things, I've taken the opportunity to thank the officials for the good work they do year-round. However, this time in my prepared remarks, the officials have put the thank you at the beginning in case I forget it or have changed my mind between now and then. So anyway, I will read it as they prepared it. Before I begin my remarks, I would like to take this opportunity to extend my gratitude to all of the Ministry of Justice staff for their commitment and hard work over the last few months to deal with the pandemic. I know the staff have worked evenings and weekends to ensure that the services residents rely on can continue. I'm grateful to be surrounded by a team that has without hesitation been there for us when we've needed it the most. Mr. Chair, if you'll pardon my bad humor, that's absolutely true. They have been outstanding and exceptional. They've risen to the occasion time and again to do things as is required to try and make sure that emergency orders were done, that they were able to deal with everything and give advice to countless ministries as we went through the pandemic. So for that, I want to thank them. I'm joined by a number of officials from the ministry today. With me at the table is Glenn Gardner, Deputy Minister of Justice and Deputy Attorney General. I'll have other ministry officials introduce themselves as the need arises. This budget aligns with our government's goals of keeping Saskatchewan strong and supporting the people of this province through the COVID-19 pandemic. We are undertaking a package of new initiatives this year that focus on enhancing access to justice. This includes new resources for family dispute resolution, protection for vulnerable individuals, and enhancements to our provincial justice system. The Office of the Public Guardian and Trustee will also be receiving over $500,000 in additional funding to better serve vulnerable individuals in our society. We will be taking significant steps over the next year to develop online innovations to modernize processes for ourselves and the public. For example, we are devoting over $3 million to the e-Justice initiative to develop online information and dispute resolution tools. This work will initially be focused on provincial offences, which will allow the public to resolve disputes online without having to travel to a courthouse. In partnership with Corrections and Policing, we'll be expanding the court's use of video technology to RCMP detachments, municipal detention centres, and correctional facilities. This budget also includes an increase of $290,000 for addressing interpersonal violence and abuse in our province. This funding will provide for a new community outreach worker and expansions to children exposed to violence programming. The Public Complaints Commission will receive $350,000 in additional funding to allow it to expand its responsibilities and commence work on increasing police oversight in Saskatchewan. We are also improving our internal practices through expanded use of the paralegal program and the creation of the Office of Tribunal Counsel. In closing, the Ministry of Justice and Attorney General is taking significant steps this year to improve the administration of justice in our province. We are proud of our accomplishments over the past year and will continue to collaborate with our government and community partners to achieve greater success in the future. The funding for the 2021 fiscal year will ensure that the ministry can continue to provide a fair and accessible justice system for the people of Saskatchewan. Those are the highlights, and now I would be pleased to answer your questions about the 2021 plan and budget for the Ministry of Justice and Attorney General. Thank you, Mr. Chair.
We will now begin with vote number 3, Justice. Are there any questions? Ms. Saar.
Thank you, Minister, for your opening remarks. And I appreciate the about the several new initiatives that the ministry intends to partake in this budget cycle. I'm wondering if you could provide some more detail on a number of them. Let's start with the family dispute project.
Kylie Head.
So we have a program that is new. You've already seen the legislation pass and the regulations pass on that. It's specifically designed to try to help people stay out of the courtroom. We find that in family litigation, as I'm sure you've experienced as well, that as time goes on, things tend not to get better between the former couple. And so the earlier you could settle, the better off the families often are. And it's better to usually negotiate and try to find a way through and come to an agreement that works for your family rather than have that imposed by a judge. And so this is a new program where we're trying to use that model in the family context. So it's a mandatory program that after the completion of filing of your, opening your file with the court and filing your documents, then before you can do anything further with the court, you have to go through one of the various options for the processes. So there's a variety of options.
I'm curious to know more about the variety of options. When this originally came through, as you remember, the legislation, the details were still very much in the works. I understand that this largely mirrors what happens already in civil litigation, but if there are more options than the way civil litigation works, I'm curious to hear more about that.
Actually, so you're right that in large part it does mirror. The idea is to mirror the civil litigation process. Originally when alternative dispute resolution and mediation were kind of a newer creature on the horizon, it was thought at the time that it probably would be very difficult to put families through that process, and so the choice at the time back in the 90s was to restrict it to that civil process. But over time, as we've developed in society and found out what a great tool mediation and all of these other tools are, we really do feel that it can apply to the family situation. So we've got a number of processes here. So one would be collaborative lawyers, so that qualifies under the legislation. And so what I would like to say, I guess, is that this is not a government program. What this is it's a court process. And so not everybody has to come to the Government of Saskatchewan for their service, and that's where it varies from the civil process. So the civil process does go through the Dispute Resolution Office, but there's a lot of options here on family side where it doesn't ever have to come to government. We don't have to see the file or touch it. So the first being the collaborative lawyers, which you'd be familiar with, so I won't go through that. But a new option as well is family law arbitration. So family law lawyers who have at least 10 years of experience working in family law and who have taken certain minimum qualifications set out in the regulations can be qualified and recognized by the minister as an arbitrator. And so the thought on that is that family law lawyers would specialize in that rather than taking existing arbitrators who may not know a lot about family law and trying to plunk them into the family law context. The next option would be family mediation. And for this, we really want to encourage the private mediation sector to grow. So you can come to the DRO and get services. We do have that option. But it's not the option that we're really promoting. What we want to do is we want to see a robust service of mediation grow up throughout the province, because there's all sorts of areas that can use mediation that would really benefit from it, not just family, but all sorts of different files and disputes. And so we really would like to see that grow. And so we're working closely there with ADR Saskatchewan and with other partners to try to develop and get more qualified mediators throughout the province. So you can come to the DRO, but we certainly, it's just an option, it's not a requirement. And then the other option is a parent coordination. And so these parent coordinators, it's a new career. So we got this idea a little bit from Manitoba, I'll confess, where they've already got that in place. But it allows not to decide issues of custody and access and those sorts of big issues. That'll be set out in your agreement. But parents, even though they have an agreement, sometimes have a hard time really implementing it or agreeing on what it is that they should do or how they should interpret it or how to communicate with each other. And so this family coordination process would have somebody who is really skilled in this area who would work with the parents and try to get them to figure out how are summer holidays going to work and how can you communicate with each other more effectively and try to work them through basic issues like that. Hopefully in the end, helping them to avoid ending up back in court. So that's sort of always our goal, is to help people to reach a positive agreement that both sides are happy with, rather than ending up in court and having something imposed on you.
How is this program working for, in the instance of an individual? I'm thinking of someone who, for example, is dealing with a partner who is not willing to participate in the court process. Are you able to note them for default, for example, without having to go through mandatory mediation?
Eventually, if we can't get them to comply, there is a process whereby you can be exempted from the requirement. But we really wouldn't want to start there, of course. We would be trying to do everything we could to get the family to work together, to bring that partner in. I'm sure the judiciary would be very frowning on anything that was going to court that didn't go through this process, and would be helpful in that area as well. So we are trying to push people through this process and get them to recognize the value. Ultimately, there is a provision in there where we can provide a certificate of exemption, or the court can provide a certificate of exemption. And so there's a very limited number of cases where we were thinking about using that, and they're set out again in the regulations. So it's situations like if a child has been kidnapped, things like that. So fairly extreme circumstances. Generally, just because somebody's not totally willing doesn't mean we're not going to work with them, because there's a lot of people that come into processes that aren't happy when they walk in the door. So if we didn't try to work with people under those circumstances, there would be a lot of people walking away. So we can't let them out the door that quickly.
How is this going to work for individuals of limited income?
So that's where the government process could work for those individuals. So under our family mediation fees, they are sliding fees, and they are done according to income. And we did want to preserve the opportunity for low-income individuals in particular to access the government program. So if you look at the fees, they do slide up considerably. So a higher income couple could come to the Dispute Resolution Office and request service, but they will pay just as much for that service as they would out in private industry. They can go get a mediator on the street for the same price as what we will charge them. They will not get a break. It's going to be the low-income couples that are going to have an opportunity under that sliding scale to access services from the government at a more subsidized rate.
Now, I think the challenge in this area is similar to the challenge often heard in civil litigation, in that it's another hurdle for individuals to have to go through before achieving their resolution through the court, if perhaps that's the stage, or achieving or ending up in pretrial where a lot of files are resolved. More expense on the individuals in terms of not just accessing this third-party services, but also for their counsel to also assist them through that process. Has the ministry looked into whether or not this actually is, as has been said by the minister, going to increase access to justice, or if it will in fact be a barrier to accessing justice?
So most people in family files never end up having a trial. So on average, there's about 4,000 applications that are made to the court in Saskatchewan every year for all different family matters. And there's about on average 50 trials per year that are held. So most people never proceed all the way through to the trial phase. It's a question of when can you settle? At what point can the parties deal with each other reasonably to come to that agreement? And we find that in the family context that by the time you finish filing your affidavits, sometimes people are more upset than they were before. And so our thought is that if we can get to those people before they have to file the affidavits, before they have to reveal all the reasons they're angry with their spouse in writing, in a very legalese document, a very formal document that can cause a lot of hurt feelings, that they may be willing to consider alternatives that are better for their children, that are better for their families early on, before they get into exchanging all those hate-filled affidavits. And so that's where this process comes in, is we're hoping that they're never going to get to those later stages, that they will be more willing early on to be reasonable and really think about what's in the best long-term interest of the family, especially when they have children involved.
The Family Matters program, is that still operational? Yes, it is. And how does that play into this?
So the Family Matters program would be separate. Family Matters is free, and so if we were to make this freely available and have it qualified under this particular program, nobody would ever go to a private mediator out in society. And we really do want, as the Ministry of Justice, to encourage the development of this professional mediation community. We really do feel, not only in family law, but all sorts of areas, that this is a very useful skill, a very useful profession that we want to see grow in the province. And so we would not want to undercut it with a free service that everybody could come and access from the government. Again, there are options available for low-income individuals, but most individuals can afford a mediator.
Accessing, I thought that mediation services were accessible through Family Matters. Is that no longer the case?
They are accessible, but not for this particular purpose.
Qualify for the completion of that.
Otherwise, everybody would just want to pick the free service. Who would pay anybody to do a mediation for them if there's an opportunity for the government to pay for it yourself? Now, there is a mediation session that is accessible under Family Matters, but it's only limited to 3 hours. That's it. It's not a long-term, it's not the sort of thing where it's going to help you work through your divorce necessarily. It's not enough time to do that. And it's often not accessed by people. Most people who are accessing Family Matters are not coming for that free mediation. They're coming for other resources, which we then steer them to, either in the Dispute Resolution Office or Family Justice Service or out in the community. We try to work with people, make sure they connect to the service that they need, and oftentimes it's not that mediation process at that step.
And what will the ministry do to monitor the impact that this change might have to low-income individuals?
So we will have to monitor that for sure. Right now, the process is starting off very slowly because of COVID. So you'll know that we only have started a pilot in Prince Albert. That was where we had selected last year to start the pilot. It started January 1st, but so far we are only aware of 6 files post-COVID that have occurred. So it's going to be a very slow startup, and we certainly will be watching for impact for low income and impact on others and impact on settlement. We want to do a full evaluation of the program, of course, and so that would be developed in time. But right now we have a very small number of files, so I really can't report any outcome to you yet. It's too new.
So just to be clear, the requirement for mediation is only operational in Prince Albert right now.
Oh, it is, yes. Everywhere else it would be optional. You could do it voluntarily, but it's mandatory in Prince Albert.
Great.
In that judicial center.
Thank you so much. The next program you had mentioned, Minister, was some initiative for the protection for vulnerable individuals. Could you provide some more detail on that?
Rod Crook, Public Guardian and Trustee. We've got a significant rebase of our budget this year from $3.4 million to a little over $4 million. The rebase reflects some significant increases in our number of clients over the last few years. So there are 2 pieces to the rebase. The first is that we've had to add a couple of staff over the last couple of years to handle the workload associated with the rising client levels. So this rebase funds those positions and the salary pressures that we've had over the last couple of years. The majority of it is for 6 new positions. There'll be 2 new trust officer positions, 2 assistant trust officer positions, and 2 financial clerks. We have a high volume of transactions, over 100,000 transactions a year, which has been on a pretty steep trajectory. It's gone up about 35% over the past 5 or 6 years. So the rebase allows us to handle that, plus it positions us going forward to meet the needs that are out there.
I'm curious to know any understanding as to why your services have been increasing over the past 5 or 6 years?
That's a variety of things. We're seeing a pretty significant increase in the number of vulnerable adult clients. It's everything from the demographics and aging of the population. We're seeing a lot more elderly people, but also we're seeing quite a few younger people with different types of issues, whether it's addictions, mental health, and those younger clients tend to be a fair amount of work given the type of situation that they're in. So it's been a variety of things. There's significant amount of financial abuse that we investigate. That's over the last few years has really increased. At any given time, we have about 40 to 60 active financial abuse investigation files. So there's a wide variety of things out there that we're involved with, and the rebase positions us very well going forward to meet the needs that are out there, as well as covering these salary pressures.
A member will be aware that we also made changes to the legislation to allow applications to be brought to set aside a marriage where it was regarded as being without full capacity, or without the understanding that was necessary, we're probably not far enough into that to be able to comment, but that was the companion piece to the rebase, was that we wanted to make sure that vulnerable seniors, vulnerable adults were protected, that we had the operations through the Public Guardian Trustee's Office, as well as the legislation to allow that. And I'm not sure whether I'm aware of any particular applications that have been made on it. And it's a challenging thing to try and identify what the type of application it is or isn't, or when it's appropriate. Somebody said, oh, you shouldn't be kicking this to the courts to decide, but I think it's impossible to do it just based on a handful of rules. I had somebody call my office and said that they were terribly worried it was an adult child that their dad was being terribly taken advantage of by this woman that had married him, and talked about all this list of abuses that the new wife had done, and that the property was being transferred into joint names. There was assets in hers. There was travel that had been taken. And I said, how long ago have they been married? Well, last night was their 25th wedding anniversary. So you can't generalize, or you can't make assumptions that this is or is not. And it could well be that the situation I mentioned, there may be one that's a far shorter period of time. So we think by having created that legislative framework that we're in a position for people to make applications to deal expeditiously to protect vulnerable people, and to make sure that we're doing it in an appropriate and fair manner. So I don't have anything to add other than that.
For that. Minister, I'm wondering if you can provide me some further information on the e-justice initiative that you had mentioned.
Yes. We have had this underway for several years, trying to sort of get where it needs to be. And the idea would be it would cover a lot of the summary offense tickets, a lot of the administrative enforcement that's done through conservation officers, a variety of other things, as well as working towards the administrative tribunals, residential tenancies, and a bunch of others. But I will let the Deputy Minister and some of the officials go on. They've done an enormous amount of work on it, and I'm hugely supportive of that, because I think it's the type of initiative, and I give them credit for it, that will promote or create access to justice that was not there otherwise, both from the parties as being either a defendant or an applicant or whatever the case may be. I think it's just an absolutely right thing to do, to take things off of the staff of a tribunal or room and to get it done where people can do things either online or with the assistance of somebody like Classic or whatever else. So anyway, I'll let, I see that Kylie is back there, so I don't think I'll need to go on much longer.
I just realized I didn't introduce myself the first time. We were probably supposed to say our names. It's Kylie Head, just for the benefit of the recording. So this is a really exciting project to be a part of. It's something that's very inspirational for people, I think, who are kind of working in the access to justice area. We are looking very much at what British Columbia has achieved, that they have taken a lot of files out of the traditional court system, and they're just having such great success with it. It's something that a lot of provinces across the country are now considering replicating or doing in their own unique fashion, because of course it wouldn't be exactly like what British Columbia is doing. But it's to give people the opportunity to deal with some of these matters that are perhaps less serious, but would take a lot of time out of their day to deal with. For example, people who are going down and want to do something with a traffic ticket. Lots of times we find people are coming to court and they don't really know what the law is. They don't have any advice. When they